An update on statutes on electronic wills. That's the subject of today's ACTEC Trust and Estates Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Connie Eister, ACTEC Fellow from Boulder, Colorado. Now that the Uniform Law Commissioners have finalized the Uniform Electronic Will Statute, it's helpful to get an update on the current status of e-will statutes. To give us more information on this topic, you'll be hearing today from ACTEC Fellow Suzanne Brown Walsh of Hartford, Connecticut, Bruce Stone of Coral Gables, Florida, and Turney Berry of Louisville, Kentucky. Welcome, Susie, Bruce, and Turney.
Thank you. In July of 2019, last summer, the Uniform Law Commission approved the Uniform E-Wills Act. And instead of calling it UWIWA, we're calling it the E-Wills Act. That act, unlike the existing state laws that we talked about in our last podcast, is a dedicated act that is simply designed to translate the traditional Wills Act requirements and make them applicable to the new medium of electronic wills. And Bruce is now going to give us some background on the why of that project.
I'm sitting here and I've got a smartphone here with me. People can't see it on the podcast, but I do everything on this smartphone. We just came from a meeting which Turney chaired, and I actually e-signed a document while we're sitting in the meeting. So I can do everything on this iPhone. Can I do my will? Why can't I do my will the same way? A lot of younger generation people are accustomed to doing everything on their iPhones and then computers. People don't have checking accounts anymore. So why can't we do that? Well, we decided in Florida, or some people decided in Florida about 2 or 3 years ago, that we're going to have electronic wills. We weren't going to wait for the Uniform Law Commission. And so in 2017 in Florida, our legislature passed an Electronic Wills Act. And it went to the governor, and it was vetoed by the governor. It came back again in 2018, didn't make it through, came through again last year in 2019, and this time it made it across the finish line, and the governor signed it. So come July 1 of this year, 2020, we're all sitting here in the state of Florida. We have a currently effective electronic wills law on the books where anybody can go online and sign their own will online. You don't have to be here in Florida, by the way. All of you listening to this podcast, if you're in Kentucky, you're in Connecticut, you are in Colorado, wherever you may be, please come in and log in and join one of our Florida remote online notaries, and you too can sign your will online in Florida. It will be valid will under Florida law, and we will enforce and carry out the terms of your will in Florida, to the extent that we can possibly do so. And so there you have it, Turney. We didn't need to wait for you guys. We went ahead and did it.
Well, we're proud of you for doing that. Are you the only state that's done that, or are there some other states that have also done that?
Well, as I think those of us sitting here know, that Arizona actually was the first to leap into the breach. In fact, I think in 2000, they actually had an electronic...
Nevada.
I'm sorry, strike that. It was
Same weather, different states.
Yeah, exactly. Sorry to my friends in Arizona. It was Nevada. And then Nevada came back and passed its law. And again, I think it was around 2017 and updated it. Next up on the list, though, I think now this is where I can mention, Arizona did pass one, and I think it became effective last year.
In Indiana?
Indiana has one as well, but they don't allow remote witnessing in Indiana. So the 2 states that really do allow remote witnessing are Nevada and Florida. And the 2 states that do not allow, which will require actual in presence, are Arizona and Indiana. So it's 2 for 2 so far. How do you deal with that in the Uniform Act?
We really give states the choice. Our intuition was that there are really 2 different parts of this project. One is a change in the medium. We've always known that you can have wills on paper. That's where most of our wills are. And of course, in law school, you'll have cases with other kinds of laws. Somebody will scrawl something on a fender when they're trapped under a tractor or in some other sort of thing. And so then the question gets to be, well, why not a tablet? Why couldn't I write my will on a tablet? If it were witnessed and notarized, does it really make any difference if it's a tablet versus a piece of paper? And I
assume you're not talking about the tablet that Moses came down.
Not an actual rock tablet. This is one that's a little bit easier to deal with than that. Doesn't require a Cecil B. DeMille or any other fancy footwork. We can all just do a tablet. And if it's witnessed and notarized, it works just like paper. But courts struggle with that, of course. I mean, they wonder. And so one part of our Uniform Act basically blesses tablets, electronic medium. So it could be a tablet, it could be a computer, it could be an iPhone, whatever it might be. Then the other piece that's much more controversial has to do with remote witnessing. So we do this electronically, and then we round up some witnesses, maybe we round up a notary, and they are not all in the same physical location. They're all present, we would say, because they are present online through something you might think of like a Skype mechanism. So it's not quite right to say that they're not there. We're not allowing witnesses and notaries to do something at another time. And I would say that it's not really that they're not present. They are present. They're simply not physically present. So we've taken a hard look at the definition of what does present really mean in this current age. But that is a very controversial notion. Some lawyers and trust officers, other people who do this kind of work, think that the absence of physical presence poses the risk of all sorts of mischief. And there are lots of other people who say it doesn't really pose any prospect of mischief more than anything else does.
So that was a source of great debate in Florida in our electronic wills legislation. And isn't it going to encourage fraud, exertion of undue influence by allowing people who can't see, they're not physically present with a testator? And so we reached a compromise in Florida. So we have carved out so-called vulnerable adults. And for anybody who's a vulnerable adult to sign a will or a power of attorney, the so-called superpowers, the powers to access your bank accounts and so forth, revocable trust. We're one of the, I think maybe the only state in the country that requires that revocable trust, which dispose of assets at death, be executed with will formalities. A lot of people don't understand that. But those categories, if you are a vulnerable adult, the witnesses must be physically present with you, even though it is an electronic will.
And who are vulnerable adults under Florida law?
There's a statute which defines that. It's not age-based. There's a misconception that it's age-based. It is not age-based.
But there's a problem with it because it includes just the physically disabled who need assistance with general tasks.
I'd like to use the example of Justice Ginsburg, when one of the times when she was in the hospital for one of her treatments, probably would have been classified as a vulnerable adult and not able to sign a will with remote witnesses.
But one thing that this talk about remote online notarization and remote witnesses reminds me of is that quietly in the background, as we were drafting our Electronic Wills Act, about 22 states enacted and are now implementing remote online notarization for other legal documents. So this is sort of this quiet background revolution that has informed our discussions and I think will make generally people more comfortable than they already are using their phones and executing documents online.
When you go through the way that the statutes, the remote online notary statutes work, there's a level of sophistication and verification so you know who you're dealing with. There are records for it. In a lot of ways, these documents will have better integrity and more security than old-fashioned paper documents.
And that's one of the things we had to defend at the beginning of this project. We had to explain to everyone who would listen to us how safe and sound these documents were and how they couldn't be forged. And it's interesting, I don't feel that we need to do that anymore. People have accepted that. They understand that because they're getting more and more accustomed to signing legal documents electronically, and they have more faith in that process.
So, Susie, our Uniform Act retains a requirement of text. Talk to us a little bit about that.
Great debates. We had great debates about whether we could tell Siri we could dictate our will to Siri and have it signed, sealed, and delivered all with our voices. There have been cases involving video wills. There have been cases involving emoji wills. And we collectively decided the world was not yet ready, or at least the United States was not yet ready for that, and decided that in our world, an electronic will had to be readable as text when it was signed. It couldn't be readable as text later or before. It had to be when it was signed, and we're sticking to that.
So you can dictate your will to Siri, and the Siri translates it into text, and then it's signed.
Yep.
That works. But you can't just
Not
have
the
it all.
reverse.
Right.
Correct.
Exactly right.
So there we go into the brave new world.
And here we are.
Well, thank you for educating us on the new frontier of electronic wills.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.